Does a Social Security judge have to consider your need for an emotional support dog in deciding your case? The answer is yes. The ALJ has to decide at step 4 whether you can go to your past work, and at step 5 whether you can do other work in the national economy in view of your age, your education, the skills you've learned, and your restrictions and limitations. Now, during the course of the hearing, the judge is going to be asking a vocational evaluator a hypothetical question about your ability at step 4 and step 5 to do work based on whatever your physical or mental restrictions and limitations might be. Now, the judge is the person who's going to be formulating that hypothetical based on the medical records in your file, the opinions of the Social Security consulting physicians, and the opinions of your doctors as expressed in residual functional capacity forms, which you should be getting your doctor to complete. Now, judges will often make mistakes in formulating the hypothetical, which can result in the VE saying either you can go back to your past work or other work. And I'm often asked, well, does the judge have to consider the need for an emotional support judge in formulating the hypothetical? So let me tell you about the case of Lee Lowry versus Acting Social Security Administration Commissioner in the 11th Circuit. The judge considered this very question, and the court held that the judge has to consider all the factors affecting a Social Security disability applicant's ability to work from a physical, cognitive, and psychological standpoint. And the court found that the judge's decision was legally wrong and not supported by substantial evidence because the judge did not consider Larry's need for the emotional support dog in the workplace. Now, I will tell you, it isn't really clear that the support dog was medically necessary because the judge didn't address it. The 11th Circuit remanded this case back to the judge, and I really hope that Larry's attorney got a letter from a treating doctor confirming that the emotional support dog was medically necessary. Now, I will tell you, judges often ignore the use of a cane or other assistive devices if not prescribed by a treating physician, and I suspect that most judges would do the same thing with an emotional support dog. So, great win. Best of luck to Lee Lowry in getting their Social Security benefits. If you have any questions about your rights to Social Security disability benefits and whether or not you can get those benefits because you need an emotional support dog, give us a call today at 727-894-3188 for a complimentary consultation. We can help you regardless of where you live in the United States.